Good morning and welcome to PV Legal's daily newsletter. Can the tax authorities issue a demand notice against a company that no longer exists? Can they raise a claim of 363 crores against a ghost entity, one that legally ceased to exist 6 years before the notice was issued? The Bombay High Court on 29 April 2026 gave a definitive and resounding answer. No, they cannot. And if they do, those proceedings are void from the very beginning. Today we cover the judgment in Vodafone Idea Limited versus Union of India and others. Writ petition number 6637 of 2025, decided by a division bench of the Bombay High Court, comprising Justice G.S. Kulkarni and Justice R.T. Sathi. This is a landmark ruling at the intersection of GST law and corporate merger law, one that every tax practitioner and corporate legal team must study carefully. Here are the key facts. In August 2018, the National Company Law Tribunal approved the merger of Vodafone Mobile Services Limited, or VMSL, and Vodafone India Limited with Idea Cellular Limited. The merged entity became what we know today as Vodafone Idea Limited. This merger was duly communicated to the GST authorities. Now, even before this merger, back in November 2017, VMSL had sold its entire tower business, over 10,000 towers across India, to ATC Telecom Infrastructure on a slump sale basis as a going concern. The petitioner took the position that a slump sale of an entire business is not a supply under GST law and therefore was not subjected to GST. 6 years later, in August 2024, the DGGI, the Directorate General of GST Intelligence, issued a show cause notice for 363 crores against VMSL, a company that had not existed since 2018. The central legal questions before the court were three. First, can proceedings be initiated against a non-existent entity? Second, does Section 87 of the CGST Act save such proceedings? And third, does the Maruti Suzuki case apply to GST? The court answered all three questions emphatically in favor of the petitioner, applying the Supreme Court's ruling in Maruti Suzuki India Limited. The court held that once an amalgamating entity ceases to exist upon the approved scheme of merger, it is no longer a legal person against whom any proceedings can be initiated. The court then examined Section 87 of the CGST Act, the Revenue's chief defense. The Revenue argued that Section 87 is a complete code for mergers. The court rejected this. It held that Section 87 is limited in scope. It applies only to the intervening period and only to transactions between the merging companies themselves. It does not empower the department to issue a notice against a post-merger, non-existent entity. The court's words were clear. The merged entity has no status in the eyes of law. Full stop. The practical takeaway from PV Legal's desk is this. If your company has undergone a merger, ensure that all GST authorities are formally notified. For the full legal analysis, subscribe to PV Legal's daily newsletter. This is your host from PV Legal, Surat. Stay alert, stay informed. Thank you for watching. Good day.